Further hearing the appeal of Ridgebury November LLC and others against Crude Carriers SA and others.
Yes, Mr. Kenny.
My Lords, you asked us to write down how exactly we said Clause 2 should be read.
Yes, we now have that.
And if it were to be held that an implied term were required, what the implied term might be. And as you say, you've had that. We're told it's inserted into your folder.
Yes.
I'll start, if I may, just by commenting on that document. In paragraph 1 of the document, we recall exactly the way in which the Court of Appeal formulated the principle. They said that the effect of the principle is that the buyers can't rely on the non-fulfillment of the requirement that Holman Fenwick should have confirmed that the account was open when they've prevented that. The question then is, how do we read Clause 2 so it has that effect? And the answer is in paragraph 2 of our document. Essentially, you read Roman 2 as subject to the qualification that it doesn't apply if the buyers have prevented the relevant confirmation.
But it's still impossible, isn't it? Because there's no account for the parties with the deposit holder.
It would not be possible upon the debt falling due for the buyers to pay that account, but that is because the buyers, have made it impossible. It's self-inflicted impossibility. They've caused the difficulty that they face.
But you've got to amend the first line of your Clause 2. Where are the buyers now to lodge the deposit?
We recognise, well, the short answer, my Lord, is they are to lodge it in accordance with the clause, and they will not be able to do that immediately because there are some preliminary steps that have to be taken. They have to comply with their duty to supply documents, and Holman then have to act upon those documents. But we recognise that it is entailed in 2 and 4 that the buyers will not immediately be able to perform the clause as it is being read. But the reason they can't perform it is because they themselves have disabled the clause from working in the way it was intended to work.
But you can't have a debt claim that's impossible to fulfil. There'd be no action for debt.
You can have an obligation to pay a person in accordance with a particular procedure, and in the event that they are unable to do it because either some part of the machinery they've caused not to work or because they don't have the money, it goes unfulfilled and they are in default.
Yeah, and the remedy is damages, not debt.
Okay, well, if I understand that point, and for that reason, taking alert to the point because of your comments, both my Lord Stevens and Ms. Burrows yesterday, we offer in paragraph 5 an alternative construction which addresses this concern, and the alternative.
But do you accept that on your proposition 2 and 4, you do not end up with an entitlement to a debt? That is, you cannot bring an action for a debt, an action for the agreed sum, under 2 and 4 because it's impossible to fulfil. I would have thought, I'm going to say this bluntly, that the answer is obvious, and the answer is no. But I may be wrong. Am I missing something?
Well, the question is whether, for the purposes of the definition of the debt, the debt can only exist if the specified account is, has been opened. And I understand the point you're making against me. It's not a point that troubled the Court of Appeal, and it didn't trouble the Court of Appeal because of the preclusive way in which they formulated the operation of the principle. So in other words, the way in which they looked at it was from an ex post facto rather than an operative construction. So they say the way in which you look at this and the way in which they define it is they are precluded from relying on. And it's relevant only because we rely on the non-payment of Holman Fenwick as a default, which then triggers our termination and forfeiting, and upon it being forfeited, we can sue as a debt owed to us. So the answer is, there will of course be a moment at which, when they fail to pay the originally nominated stakeholder, because they can't, because they're unwilling to at the same time, if that were our only, if the world were frozen at that point, your point would be a good one, my lord, and we wouldn't be able, we'd say, well, we can't sue in debt because this is a debt payable to HFW, but certainly as soon as we have terminated and forfeited, the debt is payable to and recoverable by us. And therefore, after the default and termination, our right is a right to sue them for payment to us.
But that really depends on seeing the rule as being extraneous to the contract. If you're treating it as a matter of construction or implication, then you have to work through the mechanism of the contract. You can't say it becomes a debt once the contract's terminated. If we're dealing with it as construction or implication, surely we have to take the position of, or if it's implication, the officious bystander, and say what would the words of that contract be, not what happens when there's a breach and termination.
My lord, I completely accept that point, but I just ask you to recall that there are two stages to this. The first is the question, are they in default? And then the second is, can we, following their default and our termination, sue them and recover the deposit as a debt? And the answer is, at stage one, on our paragraph 2.4 alternative, in other words, in the first two ways we put it, that there is a default when they are unable to perform their contract to pay Holman Fenwick. The obligation.
It's not in dispute
at
all that you have the right to terminate.
Yes, and
for repudiatory breach. You don't need you don't need any of this.
And then what happens when we've terminated and forfeit? We say at that point, okay, now the debt is payable to us. But now I don't. And what is the nature of forfeiting? The nature of forfeiting, where you have previously agreed that a deposit will be paid to a stakeholder, is that you say to the deposit provider, it's now payable to us. But
but why do you need then the implied term or construction? Let's just assume we haven't got that. You're in the position that you are entitled to terminate because they've not provided the necessary document to set up the escrow account. Yeah. Why can't you run exactly the same argument that says, on termination, we are entitled, as I understand it, your sort of secondary stage argument, we're entitled to have the debt paid to us?
Because you put exactly that question to me yesterday, and you said, if we terminate before no, but I mean, it's, you know, there are complexities in this, but you said to me, if you terminated, failure to provide the documents, before the debt had ever fallen due, before the obligation to pay the debt had arisen, at that stage, do you say that it would just have been damages? And I said, yes, that's right. So we need the debt as an obligation to have fallen due. In other words, we need them to have come under an obligation. The debt must be have accrued due.
Well, what's the difference? Contract is signed.
Yeah.
The very next second, the buyers say, we repudiate.
Yeah.
And in those circumstances, you say, well, this is not a debt. This is a claim for damages.
Yeah.
The very next second, the buyers say, we're not going to provide those documents. And you say, well, that's a repudiation of the contract. What's the difference between the two?
There's no difference between those. Those are just two renunciations. The question is, has something, assume that the contract's agreed on Tuesday, and it's agreed that the debt will fall due, as the deposit must be paid on Wednesday. If they repudiate on Tuesday, we've only got a claim in damages. If they repudiate on Wednesday, after the deposit has fallen due, we say, we're terminating, we've got a claim in damages, we're also forfeiting your due but unpaid deposit, and we'll recover that from you as in debt.
So you're saying, as I understand it, that these implied terms are needed at the, what I would call the second stage, in order to establish that the debt has accrued.
Exactly.
Whereas I think I had understood your argument to be, or an argument that you've got, that irrespective of these implied terms, there is an accrual of the debt just on the basis that there's a repudiatory breach by the buyers.
No, my answer to that was no, right. On the basis that this is not to foul Mr. Haynes' argument, because do you remember our fallback or our second ground of appeal is that all accrues due when you make the contract contrary to the Blankenstein.
Yeah.
Okay, but assuming the Blankenstein is right and that these are conditions to the clause 2, Roman 1 and 2 are preconditions to the accrual of the debt, then the obligation to pay must accrue, and what our paragraph 1, paragraph 2 is doing is saying the obligation to pay the debt accrues due. Now, you're right to say, without terminating, we couldn't then sue in debt, but we then say the obligation to pay the debt is accrued due, we terminate, we forfeit, and upon forfeiting, we say, well, don't worry about paying Holman's, you just pay us.
So it's a means of making your case, if I might put it this way, easier on accrual.
Yeah, it permits the accrual of the debt as a debt which can then be forfeited when we terminate.
By virtue of an implied term that can't be complied with. It's impossible to comply with.
Well, an obligation to pay,
yeah, that's okay.
the inception of an obligation to pay that they have made it impossible to comply with. Now, it may just be helpful. Well, let me because
I mean, I'm going to say something that you might regard as slightly facetious, but if we're playing the officious bystander approach, this would seem unbelievably complex to an officious bystander. It's not obvious that all this is required. You wouldn't have thought. I mean, it's not, you know, it's taking us some time to actually understand why you think this is the implied term, and it depends on a knowledge of the law about accrual, it strikes me as I would have thought, the case against you would be, well, this can't be what an officious bystander would suggest and be answered, oh, of course.
Well, what the officious bystander would say is, I don't believe the buyers can rely on the fact that Holman Fenwick have not given a confirmation when they've caused that. What nobody, let's just remind ourselves of what Lord Justice Nugent said at 106 of his judgment. So that's 151 of the bundle. What's the position if the buyer not only doesn't pay, but doesn't even do what he's obliged to do to enable the account to be open? To my mind, it's difficult to suppose that the parties intended that this should make all the difference. The obligation to cooperate in opening the account is a minor administrative necessity, but it cannot have been intended to give the buyer an opportunity to avoid paying the deposit. What the parties surely intended is that he should open the account as preliminary to paying it, not that it should give him the option whether to pay or not and leave the seller to sue for such damages as he could prove. It seems to me most unlikely that they intended to alter the balance of risks in this way.
Well, there are two comments to that. The first is it leaves open the option for the buyer to repudiate the contract the moment after he signs it. And I can't see the difference between the two at the moment. And also, an officious bystander would take into account the contractual terms. He would say, well, hold on a minute, what's the remedy? And aren't the sellers properly compensated by remedy and damages?
But what this minor ministerial task, performance or non-performance, gives rise to, it is either the accrual of a forfeitable debt with the benefit that that brings to the seller, or a remedy and damages, which only looks, it is said, at the whole transaction and whether we've suffered a loss on the transaction. So it is a radical change in the position of the parties, which is said to be brought about by the cunning ruse of not supplying documents. So, my Lord Burrows, you say, applying the officious bystander test, would the officious bystander have in mind all this stuff about accrual and forfeiture and termination? Answer, what the officious bystander would say is, I don't believe you can rely on the fact that Holmans have not given this confirmation when you procured that by the stunt of not giving them your passport. And the technicalities of how that works out is, I agree, not completely straightforward, although people who deal in this every day know about these things, but it's simply a consequence of the rules of accrual of debt, the rules of forfeiture of deposits, and the way in which all of that plays out to achieve the result. The result being, these people can't rely on the fact that they've just failed to provide their passport.
Would the position be different if the problem was, say, that Holmans had gone into insolvency? So the clause 2 became incapable of operation, but not through the fault, not through any breach of obligation on the part of the buyers.
In that case, the buyers would most certainly be able to rely on Clause 2, Roman 2, and say, look, you can't blame me for not paying the deposit because Holmans haven't given their confirmation. They haven't given their confirmation because they're bust. And at that point, you would have a nice question. It would be a failure of the agreed machinery, and we would be in Sudbrook territory. And probably the answer is that we would be applying for directions to the court, saying we have a machinery for setting up an escrow which we can't operate, and we need directions as to an alternative means of operating it.
Would the debt have arisen?
the debt would not have arisen because there's no preclusion, there's no preclusive effect of the Mackay principle preventing them in circumstances where they didn't cause Holman's not to give the confirmation from relying on that. We might say to them, but Holman, pay us why haven't you paid the deposit? They would say, we don't have to yet because Holman's haven't given the confirmation. We would say, can you rely on that? They say, yes, we can, because we didn't cause them not to give the confirmation. The preclusive effect that the Court of Appeal found arises from the fact that it was their breach of contract which caused Holman's not to give that confirmation. That's the essential point in the case.
But in my Lord Reed's example, you would not be saying that the debt has accrued and that therefore the buyers have a debt claim at the point of the failure of the deposit holder. Precisely,
yes. Because the condition's not satisfied, subject always to my having to statutorily say, without prejudice to Mr. Haynes' elegant submissions to the contrary. But yes, on the analysis on the basis that the Court of Appeal decided the case, i.e. that Clause 2, Roman 1 and 2, Roman 2 being the confirmation, were preconditions to the accrual of the debt. On Lord Reed's example, where Holman's go bust, the debt just doesn't accrue. The critical factor in this case that makes the debt accrue is because it is their breach. And their breach, what they're doing is they're setting up and relying on Holman's failure to give a confirmation when they caused that by their breach. Now, my lords, with the sort of tenacity of an advocate who puts the telescope to his eye and sees no problems with his submissions, I've ground away at that. But I'm conscious that you've bowled some fast, well, mixing my metaphors, bowled some fast balls to me on that approach to construction and implication. And therefore, in deference to your concerns about that, we put forward what in our submission is a very simple and principled alternative implication, which is the implication in paragraph 5. And that is simply to imply that, and you need to turn over the page, in the event that the buyer wrongfully prevents the above account, i.e. the Holman's account, from being opened, the buyers shall promptly lodge the deposit with the sellers. Now, I say this is simple and principled because what you have to recall, and again at risk of attributing some substantial legal knowledge to the officious bystander, but what you have to recall is that even when a deposit is payable to a stakeholder, it is a debt owed by the buyer to the seller as the creditor. The payment to the stakeholder, or the obligation to pay the stakeholder, is only a payment to an agreed payee of a debt which is owed to the seller. And that is the point, just to make that good, which is made by Lord Justice Tomlinson in the Griffin, which you find the relevant passage at 512 in the bundle. It's paragraph 20. So this is whether assuming the buyer has terminated a debt which has accrued due but payable to the stakeholder, on forfeit he can recover the debt himself. And the answer is yes, he can. And the particular words we ask you to pick up is the contractual machinery for payment of the deposit could not be an obstacle to recovery by the sellers. That approach is plainly correct. The fact that a deposit, this is just above the quote, the fact that a deposit is to be paid to a third-party stakeholder does not affect the rights and obligations of the parties to the contract, as Eve J. held in Hall and Burnett. In my view, given that both the sellers and the buyers are parties to these proceedings, sorry, and I should read, I invite you just to read the quote.
Over now. Yeah.
It might be thought that this is quite important because it's suggesting that the court can order payment otherwise than in accordance with the mechanism for payment laid down in the contract.
On forfeiture.
Yeah.
The point about on forfeiture being that the debt which had to be originally paid in accordance with the contract to the stakeholder and then be recovered directly by the seller. But what underlies that is that the deposit always was, the legal character of the deposit obligation always was a debt owed by the buyer to the seller, albeit subject to an agreement that it would actually be paid, just as you can agree that a debt is going to be paid to your nominee, to your wife, or whoever. This was subject to an agreement to be paid to a stakeholder. And the consequence of that, and I should just say that Eve J. in Hall and Burnell is essentially deciding that the way in which the deposit works is no different from how it works in a case where the deposit is paid to the seller, which is what very often, certainly historically, used to be done. And one case in which the deposit was paid to the seller is Howe and Smith, which is in our bond.
Well, just before we go to the case, the reasoning is really in paragraph 21, that it's no longer necessary to invoke the contractual machinery for payment. The existence of a machinery, whilst the ultimate fate of a deposit remained in doubt, is of no relevance now that the contract has been terminated. That's really what you were saying.
Yeah.
We see it there.
So
Can I just be clear then? Let's assume that an account had been set up by the escrow holder.
yes,
And then the buyers had simply failed to lodge the deposit. Am I right in saying that the seller could not bring an action in debt to enforce that obligation to pay the deposit to the third party, i.e. the escrow holder, unless and until there's a termination of the contract? Is that your argument? Can you bring an action in debt to get the money paid
for
to
an
the
order
party?
that the answer is, my lord, I have not researched that, and that is a point. Can you? The question really is a question about remedy, or maybe right-hand remedy. Whether in a claim in debt you can obtain an order that a third party is an order. Smith must pay my stakeholder,
Yeah.
an order made in the claim of debt, or is it an order for specific performance? My shoot from the hip answer is it's an order for specific performance, and an order for debt is always that the money be paid to the claimant.
Right. So, but you then say, so that's the simple case, you might say, but are you suggesting that at the point at which there's termination and you are forfeiting the deposit, then the position is different because the stakeholder is now taken out of the picture?
As per 20 and 21, the stakeholder drops out. So all we need is an existing obligation on the buyers to pay Holman's, whether to an account that's open or not open. That is an obligation in debt. We might not be able to get a remedy in debt at that point, but as soon as we terminate, we say, okay, you haven't paid, we're fed up with this, we're forfeiting. The forfeiture means that we can get a remedy in debt and order that they pay us.
And tell me something, just on the facts of the Griffin,
Yeah.
was it absolutely clear that that they were entitled to forfeit? Whereas here, the debt, the deposit wouldn't necessarily be forfeited. It could be held, it could be repaid to the buyers, and so on. So, on the facts of the Griffin, was the ultimate fate of the deposit no longer in doubt?
On the facts of the Griffin, the buyers had treated the failure to pay the deposit as a repudiation of the contract, so the unpaid deposit hadn't actually been paid anywhere.
Was there
the
any,
unpaid deposit
was there any argument being raised by the buyers, in that case, as to whether the deposit should not be forfeited?
Yes, that's what the case was principally about, and we'll get onto that because that's Mr. Eaton's alternative grounds of appeal. In the Griffin, the argument made by the buyer was exactly the argument that Mr. Eaton is going to make, which is that the terms of Clause 13, which say if the deposit's not paid, the seller is entitled to compensation, implicitly precluded the forfeiture of the deposit. And that's the point that Lord Justice Tomlinson rejected, and he said, no, that's not a good argument. Therefore, the deposit is forfeitable, and we have exactly, in fact, in our case, there was no argument that if the deposit had fallen due, it was forfeitable until now.
I thought there was. The victory argument.
My Lord, you're thinking of the Golden Victory.
Yes.
And the argument was that there was no loss, and therefore damages would be, but in the event that we were entitled to forfeit the deposit, there's no dispute about what the deposit that we were entitled to sue for is. It's $4.95 million. So, my Lord, in answer to your concerns, we say there is a perfectly simple and principled alternative to the constructions that we propose in 2 and 4, which is what we've proposed in 5, which is to say, in the event that the buyers wrongfully prevent the above account from being over, the buyers should promptly pay the deposit to the sellers. Now, we recognise that it will be said against that alters the commercial balance of risk and benefit by putting the deposit into our hands, and that was a complaint that Mr. Eaton made in submissions yesterday. But it doesn't change the legal analysis in any way, because as I said just before we went to the Griffin, the deposit, even while it was payable to the deposit holder, was a debt owed to us, And therefore, the arrangement for the deposit to be paid to the stakeholder is a superimposition, a bolt-on, for the benefit of the buyers to protect them. And if they thwart the stakeholder arrangement by preventing it from being established, then it falls away. They can't claim the benefit of it. And what they are left with is simply an obligation to pay a deposit, which is a debt owed to us. And therefore, the simple implication is, if you thwart the stakeholder arrangement, you can just pay the deposit to the sellers. And that, my lords, answers Stevens' concern about impossibility. It's always possible to pay us. We're ready to take the 495 anytime they want to offer it to us.
So you say all you need is an unqualified obligation to pay the stakeholder, and then because of the nature of the deposit, you say it's a debt in reality to you. A deposit is always a debt owed to the seller. It's just subject to terms as to payability, that it has to go into the hands of a stakeholder on the terms. And if they thwart the stakeholder arrangement, the escrow arrangement, what you're left with is what you have in Howe and Smith, which is an obligation to pay the seller a deposit. And of course that's not something that any buyer would agree lightly, but in this case we agreed a stakeholding arrangement and they thwarted it. So the implication in paragraph 5 deals with the impossible to pay if that were a real obstacle to the construction that we propose in 2 and 4. And it's simple enough in our submission to pass the officious bystander test. The officious bystander says, well, what happens if the buyer thwarts the stakeholder arrangement so the stakeholder can't be paid? The officious bystander would say, well, obviously he can't be paid, so you must just pay the buyer. Sorry, pay the seller. My lords,
there's just one other point I'd want to ask your views on.
yeah.
It might be said that the parties have already considered this possibility, because clause 13, sentence 1 is a response to what happens if the deposit isn't paid.
Yep.
Now, what that clause does not say is, well, the deposit then has to be paid to the seller. It says, well, at that point, contract's terminated and you get damages.
You are, my lord, essentially articulating the appeal that the buyers want to make against Lord Justice Thompson's decision in the Griffin. In the Griffin, the argument was exactly that. Look, the deposit, if it's not paid, in the event that the deposit is not paid, the first limb of clause 13 applies and tells you what happens, and the consequence is there's damages but no forfeiture.
Yeah.
And should we just look at that? I mean, I'm anticipating I have to deal with the Griffin.
I'm actually not making that point.
Okay.
I'm making a separate point, although I agree that it may, on one view, be regarded as closely related to it. The point I'm now making is this. We're applying an officious bystander approach here. It might be said against that, but the parties have already thought about this, and they've said to the officious bystander, Clause 13 is how we deal with non-payment of a deposit. They've actually thought about it.
But Clause 13, Lim 1 means non-payment when it's due.
Yeah.
It doesn't mean it can't be dealing with the circumstance that they don't pay when it's not due. And what my construction and implication is dealing with is the case where, as the buyers are saying in this case, it's never fallen due. Right? We're focusing on Clause 2 because Clause 2 determines the conditions under which the deposit falls due. Clause 13 is specifying what happens once it's fallen due if it's not paid.
Okay. Thank you.
All right. And actually, I keep trying to move on, but I also have a point to add. My paragraph 5 implication is supported by and consonant with the analysis of Mr. Chu, who says essentially exactly what we have said in paragraph 5 of our overnight document in his article, and I won't I'll very briefly take you there. It's at 1712. And the relevant passage is under heading 7. Right, and he says, assuming the accrual of the obligation to pay was conditional on the escrow account being open. Now, he doesn't actually agree with that. He agrees with the submission that Hayne is going to make, that it accrues when the contract's made. But he says, assuming that's the case, the condition could be read restrictively so that the account need not be opened if the buyers unjustifiably withheld cooperation. The debts, therefore, accrued on the buyers so behaving. The account not being in place, the buyer's obligation was simply to seek out the sellers and pay the debt in the ordinary way, failing which the sellers could sue in debt. And that is essentially articulating our paragraph 5 alternative implication. My Lords, a long time ago when I stood up, I said I had 7 points, and I was going to start with juridical basis of the rule, and I've done that, and I was then going to get on to the Court of Appeal's decision. I'll only say with reference, because we've obviously looked at the crucial passage in the Court of Appeal's decision, which is paragraph 85, and I have made the point that the Court of Appeal's approach was to treat the Mackay principle as a rule of construction, I will only just comment, because it figured largely in Mr. Eaton's submissions, that treating the rule in Mackay as a rule of construction deals very simply and effectively with what one might dub the Colley exception. Colley, I know you've looked at, but if we just look at it briefly again, it's at page 331 in the bundle. And the striking feature of Colley, if you remember the basic facts, it was a seller who refuses or fails to nominate a ship, and the buyer sues for the price, the seller says, sorry, the buyer fails to nominate the ship, seller sues for the price, but buyer says, well, I haven't got the goods. Seller says, I rely on Mackay and Dick. You've thwarted the delivery that I was going to make to you, and therefore the delivery requirement is deemed satisfied, and therefore I can recover the price. And Mr. Justice McCarty rejected that, but the striking feature of the decision is at 337, he starts by saying, I regard Mackay and Dick as equally well, as originally Scottish law, but equally well settled in English law. So if you see at 337, 10 lines from the bottom, although I, as I've said, Mackay and Dick turn on Scottish law, yet I think that the principle is equally well settled in English law. But he then says at 339 that in applying the Mackay and Dick principle, and I'm reading now from 8 lines above from the bottom in 339, a clear distinction exists between cases where the default of the buyer has occurred after property has passed and cases where that default has been before the property has passed. To the former cases, Mackay and Dick may be applied in appropriate cases. To the latter, it does not apply to enable the seller, he's making the mistake I make, but the seller to recover the price as distinguished from damages for breach of contract. Now, we simply say, with reference to that reasoning, in contract, many payment obligations are payment for the price of goods or land or services. And in such contracts, the law proceeds on the basis, other things being equal, that payment of the price and delivery of the contracted for goods, service or land are mutual conditions. And that's why in Section 49 of the Sale of Goods Act, a seller can't recover the absent special agreement, seller can't recover the price unless he's passed property in the goods. But applying Mackay and Dick, one simply accounts for that principle by saying, well, in those circumstances, it can't have been the party's intention that the seller should have the goods and the money. It can't have been their intention that he should have the land and the price of the land. And that is one of the circumstances which falls within the Court of Appeals qualification, which we summarise just by saying the Mackay principle applies except where the contract expressly or impliedly provides otherwise. Except where it's obvious that the parties cannot have intended the principle to apply, the principle will apply. And that, in our submission, does not involve any great complexity or anomaly. The third point that we take you to is what we submit as the principle underlying the Mackay and Dick principle, the background to the Mackay and Dick principle, which is the canon of construction, which is Lewison's 10th canon, which is in the bundle at page...
I mean, that's not... Sorry.
Yeah.
The explanation you've just given is not the explanation given by the Court of Appeal, by Andrew Popperwell, as far as I understand it. I mean, he starts drawing a distinction between Lord Justice Popperwell, I should have said, primary and secondary obligations, and whether it's part of the cause of action, and so on.
Well,
so your explanation is, as I understand it, a slightly different explanation.
Well, the primary and secondary obligations and the part of the cause of action are both in our submission perhaps more precise and more technical expressions of what I have presented to you as a very simple proposition, which is that the doctrine doesn't apply, the principle doesn't apply, when the debt in question is the price of goods or services not delivered. Now, how do I get from my simplistic formulation to Lord Justice Popplewell's? The answer is what he means by a primary obligation, the obligations that have to be performed in order to earn the debt. And what he means when he says an element that has to be pleaded, he's got in mind Section 49 of the Sale of Goods Act, where it is required in order to satisfy the section, and therefore the part of every pleader's particular claim, I delivered the goods, but you haven't paid the price. So one point in which our summary of Lord Justice Popplewell's paragraph 85, and you have our summary in our written case, but we put it in, it's in our written case at 56, paragraph 56, but it's in our document, in the footnote. We repeated it in the thing. The only point of divergence is between us and Popplewell, the only point at which we're not just parroting the Court of Appeal is that we say at the end of it, our words are, unless the contract expressly by necessary implication provides otherwise. And that in our submission simply captures what Mr. Eaton caustically refers to as the labyrinthine four qualifications in Lord Justice Popplewell's formulation. Now, it may be that there are very good reasons for the way in which Lord Justice Popplewell articulated it, but if you're looking for the principal justification of the caveat, our submission is it can be expressed very simply as being saying, well, this is a rule of construction. Clearly, if the parties have made a contract in terms that exclude its operation, it can't operate. And one of the circumstances in which the parties can't be taken to have intended the Mackay doctrine to operate is when you're dealing with a sale of goods case, and I'm suing for the price, but I haven't given you the goods. And McCarty's decision in Colley is just a straightforward authority for that proposition. Okay, my third heading was the principle underlying the Court of Appeal's decision, and what I had just begun to say was that the principle underlying what the Court of Appeal have identified as the Mackay doctrine is the more general principle which is expressed in Lewison on the interpretation of contracts, which we find in the bundle at tab page 1594. And what is said in bold is a contract will be interpreted so far as possible in such a manner as not to permit one party to it to take advantage of his own wrong. And then it's explained, this principle is not a rule of law, rather it's an aspect of the principle of interpretation that leans against interpretations that produce unreasonable or absurd results that couldn't have been intended. And then the example that is given is a very simple and telling one. It's Reed and Farr. And this was a lease which said the lease will be void if the rent is not paid for 40 days. The rent was not paid for 40 days and longer. And the tenant said, well, that's it. The lease is over. And the court, Lord Ellenborough, said that that can't be what the parties intended. They must have intended that the lease was voidable at the option of the lessor. And we simply say that the construction we're inviting you to put on Clause 2, and the construction which the Court of Appeal put on Clause 2, gives effect to that principle. It just can't be intended. And then I remind you of what Lord Justice Nugent said at 106. Parties can't have thought that by the cunning plan of holding their passport back, they wriggle out of having to pay a deposit.
We just look at how Chitty puts this, page 1384.
Yeah. Is that
1384?
Yeah.
So what is said there? It's been said that as a matter of construction, unless the contract clearly provides to the contrary, it will be presumed it was not the intention of the parties either shall be entitled to rely on their own breach of duty to avoid the contract or bring it to an end or to obtain a benefit under it.
Yep.
And so for the benefit, it's citing El Guisain, and for the avoiding the contract, bring it to an end, cases such as Cheel.
Yep.
Now, do you say this case falls within that categorisation?
We do.
You do?
We do.
How?
And
Okay, how?
Because the benefit that the buyers are seeking to obtain is the postponement, the indefinite suspension of their obligation to pay the deposit.
But the benefit they're talking about here is some contractual benefit.
Yeah, this
It's founding some legal right.
Okay. So when Lewison uses the word "take advantage," or when the phrase "obtain a benefit" is used, that means a benefit, a right, immunity, liberty under the contract. Right. And in this case, the benefit is the postponement of their obligation under the contract to pay the deposit. But for their clever plan in preventing the establishment of the stakeholder, they would have come under an obligation to pay the deposit. But because they disabled the stakeholder arrangement, they say that their obligation to pay the deposit didn't arise, and it is as much a benefit that a debt I'm under is postponed and has to be paid later, an obligation I'm under is postponed and has to be paid later, as it is to say that a right to receive money that I wouldn't otherwise have is brought forward. Either way, it's a benefit, because on
is there any case
they say it applies.
Is there any case that's construed benefit in that rather broad sense?
The effect of a contract to give a party a pecuniary advantage by the way it operates, it is one of the example cases in Lewison. It's Carrington, and if we go back to it, it's summarised quite neatly, although it's actually in the bundle. It's a case in which a contract provided for a rent review. The rent review clause says the rent on the review will be the fair market value of the property assuming that the property is not subject to this lease. And the court holds, assuming that the property is not subject to this lease, but also disregarding any damage to the property caused by the tenant's failure to maintain the property. Now, that is a benefit, i.e. a reduction in the lease, which the tenant might otherwise have had by reason of his breach of contract in failing to maintain the property. And the court says, no, we can't construe the contract in a way that enables you to take a pecuniary benefit from breaching your obligation to maintain the property. It's dealt with in Lewison at page 1597 of the bundle, but the actual case is in your supplementary bundle at page 202. And
Charrington's.
Carrington, Charrington. And my Lord Hammond, the question of what is a benefit and the expansive reach of that term is illustrated by Alcosain itself. There's a long contract. Is that beneficial or not beneficial? It's a right which the wrongdoer is seeking to take advantage of, just as in this case the wrongdoer is seeking to take advantage of the postponement of his obligation to pay the deposit brought about by the fact that Holmans have been disabled from confirming that the account is open.
Well, in Alcosain, the plaintiff was trying to obtain a lease.
Yes, and in this case, the defendant is seeking to avoid its liability to pay a deposit. And a lease is, of course, a continuing living instrument, but a deposit is a highly valuable feature of this commercial transaction. And if they are able to say, do you know what, my obligation to pay this deposit never accrued due, they are in the advantageous position of being able to run their golden victory argument, which is not an argument that would be available to them if the lease had operated as envisaged promptly following, if the contract had operated as originally envisaged, i.e. promptly after signing, the account was open and ready to receive their deposit.
But in Alcosain, wasn't the tenant trying to rely on a contractual clause as entitling it to a renewal?
Yes.
Where and as the laws held, it couldn't rely on the clause because it was in breach of a relevant obligation.
And in this case, the buyers are relying on Clause 2, Roman 2, to say that their liability never arose, and that's precisely what the Court of Appeal held they could not do. The essence, the kernel of the Court of Appeal's reasoning in paragraph 85 is they are not entitled to rely on the non-fulfillment of the confirmation in response to our claim for the deposit as a debt. Now, I agree that they are relying on a clause of the contract defensively, whereas in Alcosain they were relying on a clause of the contract offensively, but actually you only have to go back to Reed and Farr to see a defensive use of relying on the contract. The point in Reed and Farr was that the lessor said, where's my rent for next year? And the lessee defensively said, well, I rely on this clause that has voided my obligations as your lessee. And the court said, no, you can't rely on that as a defensive right under the contract, any more than these buyers can rely on Clause 2, Roman 2, as a defence to a claim that the debt fell due.
Still invoking a right under the contract, isn't it?
But, I mean, here they are invoking the terms of the contract to say that they didn't come under a right. I mean, it's just, I mean, our submission is it's a distinction without a difference, and the real question is whether they are seeking to say that the contract, as it applies to the facts of this case, confers on them a benefit which they would not have but for their breach of contract. And the answer is, of course it does. They are saying, because I played this clever trick with my passport, I am not under the obligation that the contract would otherwise impose on me. It's taking advantage of the terms of Clause 2, Roman 2. So, my Lord Hamlin, you said, do you say you're within Algesane? Yes, we do. And therefore, I was going to put it in this way, that what in our submission is the critical fallacy in the buyer's written document is two short sentences. At paragraph 63 of their written argument, they say, buyers are not relying on any contract term to claim a benefit under the MOAs in this case. We say, yes, you are. You're relying on Clause 2, Roman 2, to claim the benefit of the suspension of what otherwise would be your obligation to pay the deposit. And likewise, it's just the same point again. They say buyers are not relying on their own breach. This is at paragraph 134 of their document. They say buyers are not relying on their own breach to take advantage of a contract term. So that's exactly what you're doing. You're taking advantage of the requirement for a confirmation from Holman's in Clause 2, Roman 2, and you're able to take that advantage only because of your breach in disabling Holman's from giving that confirmation.
Algesane also proceeds on the basis that this is there's a presumption operating as a principle of construction.
Yes. And that is exactly why we started with Algesane, why we've gone to Algesane now.
Yeah. A construction here would be the one for which you argue in the document that you provided us with this morning.
Yeah, we say, and can I just say, I mean, we did touch on this yesterday, but maybe it's an opportunity to go back to, when I started on the document, I started by saying, I started by saying, what we've said in paragraph 2 and paragraph 4, those two very similar alternatives, are well within the parameters of the exercise of construction and don't actually require you to say, I'm implying a term. We simply say that what the parenthetical, except if the buyers have prevented it, is an understanding of the true meaning of that sentence, which is within the parameters of just construing Clause 2 without implying anything into it. That's why we regard that, we'll put that as our primary case. Can I then just remind you of little encourage on that point. And I take Lord Reed's point that little encourage was decided before Marks and Spencer's and therefore subject to. But if we could just look at little encourage, which is at 667. And look at general principles. And
which page are you on?
So 672, apologise. So 672. Now, Lord Justice Millett starts with the statement that the doctrine of fictional fulfilment of a condition precedent in civil law forms no part of English law. But then he goes on to say, the only questions which fall to be answered in English law are whether on the true construction of Clause 26 and in the events that have happened, 1, the condition precedent in paragraph C has been satisfied, and if not, 2, whether in the circumstance it needed to be satisfied. He then goes on to say, the process of construction includes, where applicable, the necessary implication of unexpressed terms and the doctrine that a man may not take advantage of his own wrong. The latter doctrine is confined to the case where a party seeks to take advantage of his own breach of a legal obligation owed by him to the party opposite. But then this is the crucial sentence. Where in breach of a contractual obligation, express or implied, a party has prevented the fulfillment of condition precedent, he may not only be liable in damages, but may also be precluded from claiming that the condition has not been fulfilled. That's exactly what the Court of Appeal decided, we say at 85, and we've proposed the wording, the construction of the words used that arrives at that effect. And then, just to see how he then applies that, at 676, under the heading, did the condition need to be satisfied, it says it follows that condition C has not been satisfied. That, however, is not the end of the matter. There still remains the question whether on the true construction of Clause 26 and in the events that happens, it's necessary for the condition to have been satisfied. And then he says at 677, in my judgment, in the middle of 677, effect can be given to the party's obvious intentions by construing condition C as if it read, C, the lessee shall, if so required, have agreed with the company. Now, that interpolation, if so required, is very similar to the interpolation that we suggest you make by way of construction of Clause 2 in our overnight document, where we say in paragraph 2, in a Millett-like italicized script, unless wrongfully prevented by the bias. It's just the same qualification. So the answer is yes, it's a doctrine, both Lewison's 10th canon and the specific application in Mackay is a doctrine of construction. And it's a doctrine of construction which leads you, in our submission, to paragraph 85 of the Court of Appeal's decision, implemented by the reading that we've proposed in paragraph 2 and 4 of our overnight document.
As I read it, that was an implication of obviousness. I mean, the preceding paragraph to make that clear.
He is saying, I mean, you'll perhaps need to look at it, but what he actually says is that it's not possible to imply any terms in this document. And that is for a slightly obscure reason, which is that it was a unilateral contract. So he actually says Marks and Spencer and implication of documents is hors de compte. It's not part of the picture. You can't start on that. But construction includes giving the words the meaning it would have, and when he says at the end of in the passage we've just been looking at, in my view, it should be read as if it said, that's not implication. That is just giving that provision the meaning that a reasonable person would understand it to have.
All right, I'll need to look at that again. The previous paragraph is all about officious bystander.
Yeah.
So,
But that, I mean, obviously, we're not only pre-Marks and Spencers, we're pre-IRC, but that is reading the document through the eyes of the reasonable person having the knowledge that the parties would have and understanding it. So it's not, I think, a suggestion that it's obvious that those words need to be added. What he's saying is a reasonable person in the position of the party, the reasonable bystander who reads the parties, as Hoffman's reasonable reader of a contract, would understand this to mean.
well, I'm not sure that is what he's saying, but I hear what you say. Yeah. Can I ask you, just to clear my own mind, the notion of a presumption of intention, a rebuttable presumption of intention coming from Al-Kaizen and some of these other cases, we now have to read all that, do we not, in the light of the modern approach to contractual interpretation. I mean, we don't look anymore for presumed intentions or rebuttable intentions. I'm not sure on your case it makes any difference, does it? Because you would say, well, you just recast all that within the modern law of interpretation. But isn't that what we've got to do? We can't go back to an idea of presumed intentions, can we?
Well, I completely accept that the modern approach, we're not in some kind of isthmus of the law removed from the mainland of wooden capita and modern learning on the construction. So obviously the approach you adopt has to be consistent with the approach that is taken to all questions of contractual construction. And I don't say I don't say this is like some special exercise, but what presumed intention means in this context is that absent indications to the contrary, that the parties are taken to have intended this. And there are plenty of examples in law and life of that kind of presumed intention playing a part. One simple example is, in the context of sale goods, parties in the absence of indication to the contrary are taken to have intended a promise that the goods will be of satisfactory quality.
Well,
and that's a
we're into
statutory...
okay.
I mean,
but that's an implication of law. I mean, we don't want to go there, because I think this is not the same exercise. I think all I'm saying to you is, I would have assumed that the modern objective contextual approach to intentional and construction is something that we have to bear in mind when we look back at these cases. I'm not sure it's any difficulty for your case.
I completely accept that. I completely accept that. And but when you look again at Al-Hussein and what Lord Jauncey says, and the way, I mean, we looked at this yesterday, you recall, and he adopts Lord Diplock's test in Cheel, and Lord Diplock is saying parties are understood to have meant, or assumed to have meant, or presumed to have meant, and maybe he's not as a presumption of fact rather than of law, but they're assumed to have meant, in the absence of contrary words, that a party's not entitled to terminate relying on circumstances he's brought about, or a party's not entitled to take a benefit relying on his own breach. And that is consistent with a modern approach that a reasonable person reading the instrument that the parties have made with the knowledge that they have and knowledge of the relevant law would say, well, this is what they must have meant.
Thank you.
Does the principle of construction, that you can't take advantage of your own wrong, Does that have any limitations?
As specifically applied by the Court of Appeal in this case, yes, and your Lordship will remember paragraph 85, where it's subject to the qualification that a party may take advantage of his own wrong. For example, if he's prevented the delivery of goods to him, as happened in Colley. So, I mean, there are circumstances where parties can't be taken to have intended some absolute obstacle.
They were formulating that in relation to the non-fulfillment of a condition precedent,
yes,
and relying upon Mackay against Dick. And, but you're relying upon this as a separate principle of construction.
What I have been saying, what I intended to say was that this principle, not taking advantage of your own wrong, is the principal justification for the Mackay and Dick principle that the Court of Appeal held applied in this case. So perhaps the simplest
way the two go together.
Mackay and Dick is an instance of a species.
Deemed fulfillment is just another, in effect, it's deemed fulfillment by another name.
Well, deemed fulfillment is one of the ways of expressing the Mackay and Dick principle. Another is dispensing with, another is deemed waiver.
So a contractor somebody who contracts to sell goods and decides, well, after all, I'm going to keep the goods, he obtains a benefit. And the purchaser would, the price wouldn't be payable.
No, that's right.
Still not payable because of a limitation.
Yeah. Yeah. And that, Colley, is one of the exceptions, obviously, that we accept and that the Court of Appeal accepted. My fourth heading was, in the event that Mackay is a rule of law, what is the basis of it as a rule of law? This is the question that my Lord Hamden put to me yesterday, and I just briefly repeat the same answer, which is, well, it has exactly the same ingredients as the principle has when treated as a rule of construction, i.e. it applies where a party has an obligation which is subject to a condition, and that party wrongfully, by his breach of contract, prevents the satisfaction of the condition. And in that event, the rule operates as an estoppel, or as Lord Donaldson would have it, a quasi-estoppel. My Lords, we then have the key cases, and as we've made clear in our written document, the cases that critically we rely on are Hotham, in which a debtor prevented the issuance of a certificate which was a precondition, or assumed to be a precondition, to his liability for liquidated damages. And having done so, the court held that the charterer's prevention was equal to performance, which in our submission simply means equal to satisfaction of the precondition. In other words, it's deemed satisfaction. Mackay and Dick, which I've already addressed to you, and I only remind you of my submission yesterday that Lord Blackburn's decision is also an application of the same rule, the same principle as Lord Watson applied. Lord Blackburn's judgment starts with the view that the price is payable after the test, and then says But on its true effect, what the contract is saying is that if the machine fails, unless the machine fails, the price will be payable. And then his conclusion is, although it's very tersely expressed, that by thwarting the test, the buyer must be deemed to have waived or dispensed with any need for a test. And that is simply treating the principle as operating by way of dispensing with the precondition rather than deeming it to be satisfied. In Panamina, which is at 949, it's very similar to Hotham. The buyer of services, ship repair services, is required to obtain two certificates, one from the Cost Investigation Bureau, government office, and the other from the ship owner's own surveyor. And the ship owner colludes or supports his surveyor in wrongfully refusing a certificate. And at 949 of the bundle, Lord Thankton says it's almost unnecessary to cite authority to establish that such conduct, that is, means wrongfully preventing the satisfaction of the condition, absolved the respondents from the necessity of obtaining such a certificate. And I only point out, beyond saying that in the Court of Appeal's decision, which is which the relevant passage of which you find at 936 and 938, you find you will see that Lord Justice Scott specifically refers to and relies on Mackay and Dick. I think what's said against Lord Thankton is, well, it's not clear that he's applying Mackay and Dick. Whereas when you look at the Court of Appeal and you look at 936, top of the right-hand column, what Lord Justice Scott is saying is that in circumstances where the surveyor has gone outside his function, one result of this was repudiation, upon which the plaintiffs could have elected to rescind and claim damages if they so choose. But another result in law was on the principles in Mackay and Dick, and also Hickman and Roberts. Now, that's a prevention case, and I'll come on to that. The plaintiffs were entitled instead to treat the defendants as preventing the performance of the term of the contract in question, and also as waiving it as a condition precedent to the plaintiff's right to sue on the cost investigation branch certificate. So that is an example of Mackay being applied in name as well as in substance. And then finally, Corrie, which you find at 342, which is Lord Justice Donaldson's decision. And again, a similar case where a party relies on his own employees' wrongful failure to certify a matter which is a precondition to the claim for the price. And he cites Panamina, but also cites Mackay. So again, this is Mackay and Dick being relied on not just in substance, but in name. And that citation obviously is at page 345 of the bundle. And then there's abacha, but noga and abacha, but we've looked at that, and I won't take you back to that. Can I just say then, critically, moving to my sixth topic, the buyer's response to all of these cases can be summarized in this way. They say all of these cases are either applications of the prevention principle in Home and Guppy or of the principle in the Karen Vartis concerning the payment of accrued debts. Our submission is clearly, starting with Home and Guppy, clearly the Mackay principle is closely related to and analogous to the prevention principle in Home and Guppy. And interestingly, in the US law textbook that we've given you, Williston on Contracts, which is in the supplementary bundle at 154, section 39.3 is Home and Guppy, prevention principle, and 39.4 is Mackay. So they put them side by side as adjoining principles. But there is a basic distinction between the two lines of cases, which is this. In the home cases, the Home and Guppy cases, the interference, the wrongful interference with the contract, and actually in home it doesn't always have to be wrongful, but anyway, the interference with the contract is by A, and the putative liability falls on B. In the Mackay cases, i.e. Hotham, Mackay, Corey, Panamina, the interference is by A, and it does have to be wrongful interference, and the liability putatively avoided is A's liability. And that's the simple structural distinction between the two, and all of the cases, Hotham, Mackay, etc., fall into the latter company. The interference is by A, and the liability avoided is A's. The buyer's argument on this point is an ingenious one that says, well, what's really being interfered with is the claimant, B's, ability to satisfy a precondition. So the interference is not, even in Hotham, they'd say, the interference by A, the debtor, is with the creditor's ability to satisfy the condition. But if you adopt that expansive definition of home, we come within it too. Their interference with the escrow arrangements prevented our ability to satisfy the preconditions on our claim for the deposit. So expanding home in the way that they have, in the classic phrase, proves too much. It just has the effect that we become a home case too. Karen Vartis, the Karen Vartis, which is this is their alternative case. They call it the Dominique point, but it's really the Karen Vartis that they're relying on. The Karen Vartis was a case in which freight had agreed to have been earned on shipment unconditionally, although it was only going to be paid after delivery of the goods. And the critical factor in the Karen Vartis was that the agreement to pay the freight was unconditional. It didn't depend on the goods actually being delivered. And so when the goods weren't delivered and the voyage wasn't completed because the ship sank, the Court of Appeal said, well, if it's unconditionally earned, payment after delivery must mean payment or after delivery or within a reasonable time. But the cases that we rely on, Hotham, Mackay, Panamina, were not cases in which the price of the relevant goods and services has been unconditionally earned. On the contrary, in Mackay, the seller's entitlement to the price of the machine was subject to the condition that it passed the test. See the interlocutor finding number 2. In Panamina, the yard's entitlement to payment was subject to 2 conditions, the second of which was a certificate from the surveyor. And if the surveyor had said, justifiably, no, I'm not certifying this because the work is rubbish, the yard would have had no claim. So the contrast between the Karen Vartis and the cases we're dealing with is the contrast between, in the Karen Vartis, a debt earned unconditionally, and in our cases, a debt that is on any view conditional. For that reason, our simple submission is that the Hotham, Mackay, Panamina line of cases cannot be distinguished on the basis that they are Karen Vartis type cases. My 7th heading is the buyer's arguments of principle against the Court of Appeal's conclusion. And they have a folio of 8 objections of principle, but I'm able to condense them into 2 objections of principle. The first is that they say that the Mackay principle is at odds with the terms of the contract. It doesn't give effect to the terms of the contract. And our answer to that is that's simply a question-begging formulation. The question is, what does, as Lord Justice Millett put it in the Courage, what does the contract actually mean on its true construction? And in particular, does the precondition for confirmation by HFW actually apply in the circumstances of this case? And the answer to that, consistent with the canons of construction and the Hotham Mackay line of cases, is it just doesn't apply. It's either dispensed with or to be treated as satisfied. Their second complaint of principle is that the Mackay principle, when applied, overrides and is anomalous as a remedial measure. But again, that's question-begging. It's assuming their conclusion. The Mackay principle is not a remedial measure. It's not a response to a breach. It is a conclusion that, in circumstances where they have breached, the relevant precondition on the construction of the instrument does not apply. And therefore, it gives effect to primary obligations of debt because in the circumstances, those primary obligations exist and are actionable. All right, those are the buyer's objection principle summarily dealt with. International materials. We have reference to your international status or your international reputation, shown you the world view of the Mackay and Dick principle. And I just pointed out that you have the French code at 1349 of the bundle. And the German code two tabs later at 1352. And then we've given you the US position in the supplementary bundle as described in Williston. And we simply summarize in this way. each of those other countries apply a version of the Mackay principle. And the oddity of if you just open 1349, if you look at 1349, at 13043, this is from the French Code, the Mackay principle is the first limb of this, and the second one, the resolutory condition, i.e. a condition that brings the contract to an end, is New Zealand shipping and Reed and Farr. And the buyers accept that we've, in English law, got the second limb, but they say, oh, the first limb doesn't apply. We just say they are simply two manifestations of the same justice and the same rule. All right, I am going to deal with the Griffin appeal. So that's everything I'm saying on Mackay, and I now move to the completely different topic of the Griffin.
Just before you leave that, I think it's probably well accepted that civil law jurisdictions tend to deal with matters by rules of law that in English law are dealt with by points of construction.
As Mr. Justice Scott said in Thompson.
So in a sense, one would expect, and you would not deny this, that ultimately your case is going to rest on, can we construe these words in the way that you've put forward? Can we put an implied term in it? That is what you would expect the common law approach to be.
Precisely. Yeah. I don't say we need to follow the rule of law approach, and indeed my case has always been, in this House, the Court of Appeal were right to treat this as a rule of construction. Okay, I come to the Griffin, and on the Griffin, there are two questions. One is this appeal open to the buyers to advance? And the answer is it's not, because this is not within the parameters of the question that they got permission to appeal on. And if you look at the question that they got permission to appeal on, which is at page 228, the question, where an obligation for payment within a contract is contingent upon the fulfillment by one party of a condition, and that party fails in breach of contract to fulfill that condition, is the condition deemed to be fulfilled with the result that the payment sum can be claimed by the other party in debt, or must the claim be in damages, is a claim concerned with the Mackay principle, which was the question that was debated in front of the arbitrators. There was no debate in front of the arbitrators, and there is no reference in this question to the question that is now being advanced, which is assuming that the condition is deemed fulfilled with the result that the deposit falls due, is the deposit nevertheless not forfeitable because Clause 13 has that effect? That was not a point that arose before the arbitrators. It's not a point on which the arbitrators expressed any view. There was no argument about it.
So the arbitrators would have been bound to follow the Griffin.
Yes.
So how do you raise it?
You can't
as
in
an
arbitration.
appealable question.
You can't in arbitration. You would have to say to the arbitrators, the Court of Appeal is wrong on this.
Yes.
And I invite you to say that the Court of Appeal is wrong. You're an arbitrator. They would then make an award saying, I reject this submission, of course the Griffin is right.
The judge giving permission would have to be satisfied, although bound otherwise, to consider that
the
Griffin was prima facie wrong.
Exactly.
Strong prima facie.
And the answer is the Griffin is not, for practical purpose, assailable in arbitration. It's just not. It's part of the furniture.
But how do you get through the permission to appeal hoop of strong prima facie case of something being wrong?
Well, that's why I say it's, for practical purposes, it's unassailable. Because they would have had to say that the Griffin's wrong, and the arbitrators would inevitably have said, well, the Griffin's right, and we regard ourselves as bound by it. They would have appealed, saying the arbitrators were wrong to do that, and the judge would have said, however wrong I think Lord Justice Tomlinson was, I don't think you've got a realistic prospect of establishing there's a serious doubt about this decision.
So you're never going to be able to get before the courts a question of law in which there's binding authority by the Court of Appeal or the Supreme Court, however wrong-headed it may be.
No, and indeed, since the criterion is public interest, and since, as we explain in our written case and expand in our written case, the certainty in the commercial law is of paramount importance, it's right that people should not, through the exceptional jurisdiction, having chosen to arbitrate, it's right that they should not be given the opportunity to take on Court of Appeal cases. The unattractiveness of the suggestion that they should be able to do so is reflected in the position we now find ourselves in. You would have seen in the supplementary bundle that the Saleform 2022 has since come out, and the Saleform 2022 is drafted in terms that confirm and give effect to Tomlinson's judgment in the Griffin. So what these buyers are now trying to do is say a historic form of the form, which has been the subject of a binding, till now, binding Court of Appeal decision, with which the commercial world has gone along for more than 10 years and now confirmed in the latest form, is wrong, and that now there should be a difference between the current version of the form and the historic version of the form. It's the sort of point in which if they had been able to make a credible permission to appeal, the first instance judge would have said it's just not a suitable point to give permission on in the light of the public interest considerations. Okay, so we say patently, looking at the drafting of 228, this does not embrace an issue as to whether the Griffin was right and whether, if the deposit did accrue due, it was not forfeitable. It's suggested that Sharp and Vitera provides a warrant for amending the question, and that is not right, because in Sharp and Vitera, the question, the test is expressed to be, is the new question, is the substance of the new question the same as the old one? And this is, in substance, a wholly new and different question. Is the Griffin wrong? The answer is the Griffin is plainly right for the reasons that Lord Justice Tomlinson gave. He says, you have to recall, when construing Clause 13, that the premise is that the deposit has accrued due and is forfeitable. In other words, the claimant sellers have an existing right to sue for the amount of the deposit as a debt. So what you are asking when you construe Clause 13 is not, is this a clause which confers a right to sue for the deposit as a debt? You're asking, is it a clause which is sufficiently clear that it, and it would have to be implicitly, it implicitly divests the sellers of the right to sue for the deposit as a debt? And Lord Justice Tomlinson rightly says that there is a test for divestment. Clauses that are said to divest you of your common law rights. The test is in Gilbert Ash. It requires clear words. And Clause 13 does not contain clear words. Although, for those reasons, you should not allow the Griffin appeal to go forward, but if you do, you should dismiss it.
Thank you. Yes, Mr. Hayne.
My Lords, given the time, I'm going to skip straight to the substance of the question. Whether the conditions in Clause 2 are conditions to accrual or payability. The buyers say that they are conditions to accrual. We, supported by Rob Stevens and Jonathan True, say that they are conditions to payability only. If we are right about that, it means we can recover them as debt upon termination for repudiatory breach immediately. In other words, it would, as I understand it, allay my Lord Stevens' concern, which is, well, why does it make a difference whether you terminate straight away or terminate after they've prevented the deposit holder from opening the account? So it answers that question. I've also had the benefit of looking up the question that my Lord Burrows asked of Mr. Kenny, which is, well, could you compel compliance with the deposit escrow arrangement before termination? Answer is yes. The reference is in the Commercial Duties book at 27036. It's not in the bundle, but the most famous example we'll all remember from undergraduate days is Besic and Besic, which is the privity case. So you can enforce a money obligation that is owed to a third party. I want to make 4 headline points. First, we say that as a matter of language, the deposit is expressly agreed to constitute security for the correct...
Sorry, 27... what was the reference you were giving?
27036.
Of
Which book?
Of the Contractual Duties book.
And where's that?
Is it in the bundle?
It's not in the bundle. It's not in the bundle.
Contractual duty.
I'll send it over after.
Thank you very much.
And it deals with the question of whether the specific performance of money obligations. The answer is yes, and one example is whether money obligation is owed to a third party. There are other examples like pensions and duties. So,
Yeah, I think that...
and it is then
Maybe that specific performance is different from the award of the agreed sum. But anyway, let's not delay. Yeah.
And so the question was, could you enforce it before terminating? The answer, yes, you could. First, we say as a matter of language, the deposit is expressly agreed to constitute security for the correct fulfillment of the entire agreement, not just parts of it. Second, we say the deposit accruing upon agreement accords with the commercial purpose of deposits. It is, as Lord Justice Nugee put it, protection against being messed around. It is also the quid pro quo for taking the vessel off the market, and that happens immediately, as recognised by the Hong Kong Final Court of Appeal in Polyset and Mr. Chu in his article. Mr. Chu cites the relevant decision of the Final Court of Appeal of Hong Kong. We've put it into the supplemental bundle. Third, if one tests the rival constructions against their practical effects, the buyer's construction results in a lacuna in the contractual allocation of risk, because the seller is locked in, but the buyer gets to choose whether or not to provide security. And Mr. Eaton yesterday quite frankly accepted that. He said that, yes, before the account is open, the buyer basically gets a choice. They've bought themselves an option. And we said that results in an uncommercial outcome. The buyer had an option whether to enter into the MOAs. They exercised it, they entered into them, and that is that. And fourth, if I have the time, I'll briefly address the Blankenstein. And the short point of the Blankenstein, my lords, that was an arbitration appeal, and in the arbitration, damages only were awarded. There was no appeal on the basis that a debt should have been awarded. So the discussion as to whether this would have accrued due was only in the context of what the amount of damages should be, and in particular of whether it should be the market loss or whether it should be the amount of the deposits, which was about 4 times higher than the market loss.
You're still saying we've got to overrule it, aren't you?
We said it in our written case, and on further reflection, we probably put it too high in the written case. We said it had to be wrong. It's not wrong as a matter of stare decisis if the question wasn't put before it, which it wasn't, and therefore you can say that part of the reasoning are wrong, but it is, in fact, probably only Lord Gough's reasoning. And because you've asked, let's just go to Blankenstein. It's at 364 of the bundle. This was an older version of the Norwegian Saleform. The purchase price was 2.3 million. You can see that at D. You can see that the deposit was 10%. That's also at D. And then at H, we can see that the arbitrator awarded $60,000 by way of damages. And the question was whether they were entitled to the amount of the deposit, which was $236,000. The appeal against Mr. Justice Leggett's decision was dismissed by majority. And if one looks over the page, at page 365, the head note correctly records that it is per Robert Gough LJ that the obligation to sign the Memorandum of Agreement and the obligation to pay the deposit does not accrue until the memorandum is signed. On repudiation of the obligation to sign, the sellers are entitled to the normal damages for breach of contract. That's the market price. So that's the golden victory point. It's called the golden victory point, but it's just, the point is a simple one, which is there was no loss on a market measure. So the arguments that one actually had to deal with were mostly related to the question of whether there was a contract at all. And one can see that at 371 of your bundles, my lords. 371, between F and Z, Lord Justice Fox's majority judgment sets out the 3 questions to be determined. Was there a binding contract concluded at all? If so, was it binding upon Damon? That turned over to Damon ratified it. And thirdly, can Hapag-Lloyd recover the amount of the unpaid deposit? This was all in the context of a damages claim. There was no debt claim in front of the Court of Appeal. We don't know whether there was a debt claim in front of the arbitrators. There certainly wasn't one in front of the Court of Appeal. And if we then have a look at 378, which is Lord Justice Fox's judgment, between C and D, he expressly says that as to whether, if Damon had been sued for a deposit as such, it could have avoided liability by pleading its own breach of contract in failing to sign a memorandum, I express no view. The matter was not investigated before us. So the question related entirely to the quantum of damages, and in that context, if one looks at page 380, one of the points that was discussed was whether Low and Hope or Dewar and Mintoft had been correctly decided. Those were 2 conflicting first instance cases, and in Dewar, one can see at C, that the jury had been instructed to award the amount of the deposit as damages, Then in Low and Hope, this was said to be wrong, but the Court of Appeal accepted Mr. Morbeck's submission, and you can see that at H, that the right of the vendor to forfeit the deposit is not, however, dependent upon completion of the purchase. The right to forfeit arises out of the breach and is therefore something quite different from the right to receive the purchase money in return for conveyance. The result, in my view, is that Dewar and Mintoff was rightly decided. And then it is in this context that Robert Goff, Lord Justice, deals with the question of whether the deposit accrues, and that's at 385. Between E, F, and G, one can see that he says if the repudiation occurs after Damon had paid the deposit, Hapag-Lloyd would be safe. They would have the deposit and could keep it. If the repudiation occurred after the obligation to pay the deposit had accrued, but before Damon had paid it, Hapag-Lloyd could also sue Damon for the deposit.
As a debt.
As a debt, correct. And the language of this not accruing due is at C, where, yes, I accept Lord Justice Goff is against me, but that is because the difference between it being due and it being payable was not argued. The protagonists in this case were the same Mr. Morbeck and Mr. Eder, as then argued to Dominique, but the Karen Battis hadn't sunk until a year after this was decided, and the Dominique hadn't even had proceedings issued by this. So they might not have argued it because there was no point arguing, because there was no debt claim in the arbitration, or for some other reason it wasn't argued. But the difference between accrual and payability was not part of the ratio of the Court of Appeal. And to the extent it was decided by anybody, it was decided by Lord Justice Goff and the minority.
Can I just ask you about that difference in the context of Clause 2? If we just look at Clause 2 for a moment.
It's 180 of the bundle.
Yep. We've looked at it now a number of times. We can see it tells us that as security, buyers shall lodge a deposit in an account for the parties with the deposit holder within 3 banking days after the date that Roman 1, this agreement has been signed and exchanged, and Roman 2, the deposit holder has confirmed in writing to the parties that the account has been fully opened and ready to receive funds. Now, as I understand it, you say that you accept that the deposit only becomes payable when Roman 2 is satisfied.
Yes.
Now, when do you say the deposit becomes due?
Immediately. And the reason I say that, my lord...
And that, immediately is when the agreement has been signed by the parties?
No, when they've entered into it. So subject to signature being a condition precedent to it becoming binding, the parties can enter into this agreement orally, and as at that date, there is a binding contract, we say it falls due. And the reason I say that, my lord, is because of the first word in line 31, which are as security for the correct fulfillment of this agreement. And we say this agreement means the whole agreement and includes, in particular, lines 41 and 42. That is, it includes the obligation that is part of this agreement to provide all necessary documentation.
So what's the purpose of Roman 1?
It's a timing point, my lord. So it goes to timing. It's like in the Karen Battis, where it's within 20 days of discharge and the statement of facts. So there are 2 conditions, discharge and statement of facts. And the Court of Appeal says that tells you when the time starts ticking, but it doesn't tell you anything about when it accrued. My Lord, I'm conscious of the fact...
I wanted to be clear about this because obviously this is a standard form of contract in wide use. So you say that under this contract, although it's not said expressly, the effect of a contract, the effect of this document, of this form, is that the deposit becomes due when the parties agree. Well, I don't want to put words into your mouth. Could you give us the...
As of the date when they enter into the agreement. And entry could be contingent on a formality, but it need not be. As of the date they've entered into the agreement, there is a binding contract. The deposit is due, albeit not payable.
Yeah.
My Lord, I'm conscious...
And due means the same as accrual?
Yes.
Yes. And when you say enter into the agreement, that's not necessarily the signature of this form.
Exactly. Yeah. The signature might be a mere formality. Sometimes these things are entered by email, but nevertheless they want to...
As in the Blankenstein.
Yeah. Thank you very much.
I'm conscious of the fact that unless I sit down literally now, I'm eating either into your lunch or Mr. Eaton's submissions.
You've got a... I think you actually have...
I'm told I have 4 minutes.
You have a few minutes, yes.
There we go. Well,
You've got 4, yeah.
Then turning to purpose, we say that the purpose of this is as described by Lord Justice Newgee and as described by Mr. Chu in his article and as described by the Hong Kong Final Court of Appeal. But there's one particular submission I wanted to deal with, which is that Mr. Eaton's submission is that it can't be due because at the time when it's lodged, its ultimate status depends entirely on future events. It is not paid as something they have earned. It's purely provisional. It may all come back to us. This was at 12:54 yesterday. So the submission, as I understand it, is that a deposit cannot be due or cannot be payable if it is potentially repayable. That submission is wrong, my lords. Take a very simple case. A buyer and seller enter into a contract with delivery of goods taking place 1 year from now. The contract provides for 10% deposit payable immediately. It also provides for part payment of 40% of the purchase price 6 months from now. The remaining 50% is going to be paid on delivery. If the deposit is not paid, can the seller sue the buyer for the deposit? We say yes, it is due and payable. The buyer cannot say at that stage, well, hang on, you can't sue me for this because I may be able to get the deposit back if you renounce the contract in 5 months from now, or if the goods are so defective, I can refuse to accept them. What about in 6 months? Can the buyer sue for the 40% prepayment? Again, we say yes. Again, the buyer cannot resist that action by saying one day it might get it back. The fact that the deposit is potentially repayable tells you nothing either about whether it is a deposit or part payment, or whether it is accrued due or become payable. And the same analysis holds true if it is payable to a third party. Looking at the effect that these various constructions have, we can see in the LMCLQ article of Professor Stevens how he says this would operate, which is that if for any reason the deposit arrangement falls apart, you simply imply a reasonable substitute. So if HFW go bust, you read it as saying, or other reasonably agreeable substitute. That is how I understand Professor Stevens' article.
I don't think he does say that. I think he says the debt becomes immediately payable. Does he mention the words reasonable substitute?
He doesn't, but...
No. Well, I won't delay you now.
No,
that may be...
Certainly that is my...
That's your interpretation.
That is... putting to one side my interpretation, wrong or otherwise, of what Professor Stevens is saying, that is our submission of how this works.
Mr. Hayne, at some stage, are you going to be dealing with the question as to whether this point is open to you at all? Because the judge at page 174, paragraph 121, decided the point against your clients. And that was that the confirmation that the escrow account was open and ready to receive funds was a precondition to the accrual of the buyer's obligation to pay the deposit and the seller's correlative right to sue for it. And so the point taken against you is you didn't appeal that or didn't get leave to appeal it.
Let me deal with that very briefly, my Lord.
Yes.
The answer is the point is available to us. The reason it is available to us is because Section 69(8), which is at page 243 of your bundles, my Lord. of the bundle, Section 69(8 provides that no appeal lies without the leave of the court, which shall not be given unless the court considers that the question is one of general importance, or is one which for some other special reason should be considered by the Court of Appeal. Now, I emphasize the words Court of Appeal. 3 points, my Lords. This section says nothing about appeals to the Supreme Court against judgments of the Court of Appeal. Those are not governed by this section. In any event, Section 69(8) is directed at appellants, not at respondents. It places no limits on the points that a respondent could take by way of respondent's notice in the Court of Appeal. It doesn't say anything about those. And drawing those 2 points together, my Lord, this subsection places no limits on the alternative or additional grounds taken by a respondent, that is my clients, in the Supreme Court. Mr. Barnard actively disclaimed any reliance on procedural rules because we complied with the procedural rules for taking a respondent's notice point. He relied on statute and he relied on principle. Although he didn't identify it expressly, the principle would have to be that a party cannot argue a point in the Supreme Court that it did not argue in the Court of Appeal. There is no such principle. When my Lord Hamlin yesterday asked whether this was a pure point of law, I understood him to be alluding to a line of cases where appellate courts do not allow new points if they would have changed the complexion of the trial. Those principles were recently summarised by Lord Justice Popwell in Ryan Shipping and Vitol in 2024. But those authorities are not and are not set to be relevant. More generally, as your lordships know, there are many cases where this court is asked to decide whether a decision of the Court of Appeal, the House of Lords, or the Supreme Court was correctly decided in circumstances where that argument was not, indeed could not, be made below. A very recent example is the Polska and Jakubowska decision, where my Lords Lord Reid, Lord Hodge, and Lord Hamlin were part of the 7-member panel. The logical consequence of Mr. Barnard's submission that arguments are unavailable in this court if they were unavailable in the court below would result in the absurdity that this court could never overturn one of its own decisions. That is because in each of those cases, those arguments were definitionally unavailable below.
Now, Mr. Hayne,
I will now.
We're going to have to let Mr. Eaton get onto his feet, I'm afraid. We're very grateful to you for your assistance, and we have quite a full written argument.
I'm grateful.
Thank you very much. Yes, Mr.
My Lords, paragraphs 2 to 4 of the document that were handed up to your Lordships overnight propose 1 construction and 2 alternative implied terms for Clause 2 of the MOAs. The problem with all 3, as Lord Stevens pointed out on more than one occasion, is that they import an obligation to do the impossible, to pay the deposit into an escrow account which by definition has not been opened and therefore by definition does not exist. Now, my learned friend, Mr. Kenny, breezily swept this aside on the basis that it's an everyday occurrence that a party may be subject to an express or an implied obligation and disables themselves from performing it so that it becomes impossible. And it's not a problem. Now, that's not what's being proposed in these formulations. This is not a case where you start out with an obligation which is prima facie to begin with possible, but the obligor, by his own conduct, disables himself from doing it, and that's no excuse. It is in the nature of these formulations that from the very moment that the underlined words kick in, the very moment that the construction or the implied term becomes relevant, that the obligation cannot be performed. It can never be performed. These are, by definition, impossible obligations. And I do, with respect, take up my Lord Borough's point. The officious bystander is not going to say it's a matter of necessity or obviousness in the construction of these contracts or the approach to implied terms in these contracts, that you've got to read them as subject to some obligation which can never be performed. The officious bystander, in my respectful submission, would be absolutely baffled if one was to suggest that. And that is why one gets into the formulation, the alternative formulation, which is in paragraph 5 of the document. My learned friend was quite clear about this. This is an attempt to get round the impossibility aspect. And so that postulates that instead of paying the escrow holder, when the underlined words kick in, we have to pay the money instead to the sellers themselves. Now the problem with that is you just cannot get away from the fact that that is rewriting the contract. It's not construing the contract. It's not a question of construction, it's a question of contradiction. And any implied term to that effect would contradict the contract. And it is not simply a matter of form, it's a matter of substance, because, as I understand my learned friends to accept, the purpose of the escrow holder provision is precisely to make sure that they don't get their grubby mitts on the money until they're entitled to keep it because they're entitled to forfeit. And this just drives a complete coach and horses through it. The money is not payable to them under the contract. The obligation to pay it is plainly an obligation which is owed to sellers, but the obligation is to pay it to the escrow holder. There's a comment in the Griffin, my learned friend referred to this morning, about the interposition of the deposit holder doesn't alter the fact that it's a debt payable to the sellers themselves. But I think, as my Lord Reed pointed out, that was a comment which was being made in a context where the money has become forfeit. And clearly at a point where it's become forfeit, no one's going to suggest, well, you have to channel it formally through the escrow holder and the escrow holder will pass it on. But at that stage, if it's become forfeit, understandable that the sellers can sue direct to recover it. But we're concerned here with a point at which it's accruing. And at the point that it accrues, to whom it is payable? And it's perfectly plain on the face of the contract. It's payable to the escrow holder and nobody else. And with respect, you cannot by any process turn it into a contract to pay the sellers when that's entirely the opposite of what the contract's intended to ensure. Now, the way it's put by my learned friend by reference to Mackay, and in particular by reference to Lord Blackburn in Mackay, is, well, the buyer's conduct precludes them from relying upon what the contract actually says, and therefore they're somehow precluded from saying that this will be rewriting the contract. But with respect, that is a misreading of Lord Blackburn's ratio. It's suggested orally, and it's suggested in Sellers' case at paragraph 67 and following, that Lord Blackburn really takes, albeit in slightly different language, materially the same approach as Lord Watson in terms of looking at the fair trial as being a condition precedent to the obligation to pay the price. And in my submission, that's a misreading. When you see that Lord Blackburn's analysis begins with the Mildenhall Bell case, which is a case of a penal bond and therefore by definition about conditions defeasant, when you see that Lord Blackburn's analysis concludes with the formulation that Mr. Mackay was bound to keep and to pay for the digger unless it failed a test, it's clear in my submission that Lord Blackburn's analysis is condition defeasant. The condition defeasant was not satisfied, and therefore, by definition, Mr. Mackay had to pay. It's nothing to do with preclusion, waiver, deemed waiver, estoppel, quasi-estoppel. It's simply a straightforward application of condition defeasant learning. And that's not just my submission. It was the view of the Court of Appeal in this case at paragraph 29, that's page 129 of the bundle. It was the view of Mr. Justice Bacardi in the Colley case, page 337, of Mr. Justice Devlin of Mona Oil, page 773, Benjamin, 1424, Carter's breach of contract, 1443, Good and McKendrick, 1527. I mentioned Colley. My learned friend highlighted that Mr. Justice Bacardi and Colley said that Mackay was part of English law. I just ask your Lordship to note the only judgment which Mr. Justice Bacardi refers to in Colley is Lord Blackburn's judgment. There is no endorsement or indeed reference to Lord Watson's different analysis. The other point about Colley is my learned friend suggested, as he does in writing, that, well, the reason that the Mackay principle doesn't apply to Colley and other cases is readily explicable in terms, well, that's just the intention of the parties. The parties, in a case like Colley, don't intend the debt to be recoverable unless the goods have been delivered. Now, that's obviously right. But, as we say in writing, the intention is not some abstract intention, it's the intention expressed in the contract. The way the contract is drafted in a sale is that the right to the price is obviously conditional upon the transfer of the goods. And we make the point that in this case, the right to the lodging of the debt, the obligation to lodge the debt, is conditional, it's expressly conditional. So as we've submitted in writing, the analysis has to be that there is some process by which the court arrives at the conclusion that when the obligation is made conditional in a case like Colley, the parties really mean it. And when it's made conditional in a case like this, the parties don't really mean it. And how one draws the line is just entirely obscure. And it is notable that when your Lordships read the Court of Appeal's analysis, the Court of Appeal do not explain what they call the Colley exception in terms of intention. They do, as my Lord Borough says, they explain that by reference to primary and secondary obligations and the old rules of the Supreme Court about pleading. But as I said yesterday, that is not a principled exception. That is purely descriptive of a type of case to which the Mackay principle does not apply, with no explanation of why not. And there is no explanation of why not. Now, it's quite interesting. My learned friends have put in some comparative material. The French code and the German code, on their face, would appear to lead you to the conclusion that in a case like Colley, the seller recovers the price. And if your Lordships look in the German material at page 127 of the supplemental bundle, as I read it, that appears to be what the German position is. There's a reference to a sale, and the buyer refuses to accept the goods, and the German material appears to say that the seller recovers the price.
Could you give me the page number, please?
127 of the supplementary bundle, my Lord. Now that may be German law. And indeed, that is the logic of the principle that's being postulated by my learned friend in this case. And it's hard to see any principled stopping point short of that. And the Court of Appeal does not propose a principled stopping point short of it, in the sense they don't explain why that is not the logical consequence. But if it's the logical consequence in German law, I mean, it's plainly not English law, and has not been since Laird and Pym, probably before Laird. The American law, I just ask your Lordship to look at 189, in not right now, but in your own time, of the supplementary bundle. That is Williston, talking about the consequences of one party preventing performance of a condition. It's notable that that section is headed Prevention as Breach, the Right to Damages. It is true that once you get into the body of it, about halfway down the first page, there's a bit where Williston talks about the innocent party having a right to the price, which sounds a bit like the debt accrues because of the breach. But when one reads on, that's immediately qualified, and the ultimate conclusion that Williston comes to is to say that the plaintiff cannot ultimately recover more than if the contract had been performed. And when you look at Williston and indeed the restatement, it expresses two principles. One is that, in substance in my submission, one is that if D prevents P from performing, then D cannot sue P. P is excused. And in my submission, that corresponds really, that's the Home and Guppy principle. And then the second principle is stated that if D prevents P from performing so that P cannot render the quid pro quo which triggers D's performance, that doesn't release D. D is liable. But that's Laird and Pym. You can't get out of the contract by preventing the other party from performing their own part. You are liable, but then the question is liable for what? Laird and Pym says you're liable for damages, not for the debt. So in my submission, there's nothing on the face of the American materials which actually takes matters any further than the English position as expressed in Home and Guppy and in Laird and Pym. I gave the Lordship yesterday our submissions about what we say is the structure of the contract and the commercial consequences of the contract being structured in that way. And with respect to Lord Justice Nugie's observations in this case about not being able to believe that the parties intended any different by the way they structured the contract, I would, with respect, commend to your Lordships Mr. Lord Justice Robert Goff's analysis in the Blankenstein, at page 377, where he says that because of the structure of the contract, in that case, because the deposit becomes payable at a time after the contract is concluded, he says that that has the effect that whether the seller's remedy is damages or forfeiture of the deposit may depend upon the timing of the repudiation.
Yeah.
But he says, well, that's just a consequence of the contract that you entered into. And the
It expands on that on 385.
My Lord, yes.
And it's actually dealing with the Norwegian Saleform.
The Saleform. And the Court of Appeal of Singapore in the Anaspiratu, which your Lordships have at 1364, they come to very much the same analysis. And we submit that is the contract. I submitted yesterday. It's a sensible commercial compromise when it comes to what we're going to do about the deposit. But whether it's sensible or not, it is the bargain which the parties made. And there's no reason why the court should seek to reopen it and amend it or improve it from the seller's perspective. The suggested reason why your Lordship should do that is this theme that otherwise the buyers would be benefiting or taking advantage of their own wrong by failing to provide the documents. There's no principle of English law that a contract breaker cannot be better off by breaking the contract than by performing it. We've dealt with that in our written case at paragraph 152. And in any event, we say it's not right that we'd be better off by breaking our obligation to provide the documents for HFW and not lodging the deposit than we would have been if we had performed the obligation. Because if our golden victory point is right, then if we'd provided the documents to HFW and we paid the deposit, it would all have come back to us. And what that actually means is that by not paying the deposit, by not providing the documents to HFW and not paying the deposit, we end up in exactly the same place we would have been if we had. No better off at all. It's an identical place. We're not taking advantage of our own wrong. We're only better off in a counterfactual world where if we had provided the documents to HFW and the deposit had accrued due and we paid it, we would subsequently have forfeited it because we'd have broken the contract in some other way by refusing to pay and take delivery. As I said, yes, there's no finding of that. Not so we argued in the arbitration. There's no finding that would have happened. And it's not a plausible counterfactual, because if we had lodged the deposits, we'd have been making a pretty big financial commitment to this contract. You'd expect us to go through with it. And with respect, these sort of counterfactuals, what would have happened if you'd lodged the documents, followed through with your obligation to lodge the deposit, who would have been better off, who would have been worse off? These are the sorts of counterfactual analysis which are dealt with in a claim for compensatory damages. And that, in my submission, rather highlights why compensatory damages is the appropriate remedy here. My Lords, my learned friend made some submissions on whether the principle is a principle of construction or a substantive law. I do submit that there's some degree of lack of precision in that about precisely what the principle being discussed was. And we've said in our case at 136 following, we submit that's also something of a feature of the Court of Appeal's analysis of the case law. There's reference by my learned friend and the Court of Appeal to cases like Shiel, Al-Hussein. Shiel is authority for quite a specific proposition as a principle of construction that, so far as possible, a termination clause should be so construed that a party cannot invoke the right to terminate if the conditions for invoking the clause have been brought about by the party's own breach. It shares a philosophy with the principle that you cannot rely upon your own self-induced frustration to get out of a contract, and probably with the general principle, subject to exceptions, that termination for repudiation is only at the option of the innocent party. The guilty party can't say, I've repudiated, the contract's over. Al-Hussein extends that principle to cases where a party seeks to rely upon its own breach to invoke a clause which gives the party the benefit of new rights under the contract, and which correspondingly would impose new obligations on the other party under the contract. Now, with respect, my lords, with respect to my learned friend's attempt to suggest otherwise, none of that's got anything whatsoever to do with this case. We are not seeking to terminate, either by reliance on our own breach at all. We don't claim a right to terminate. We're not seeking to trigger a new bundle of rights and a new bundle of obligations. All we say is that the conditions under which our obligation to pay the deposit were not engaged. My lord, final point. As I said yesterday, the principle to get my learned friends where they want to get to, the principle has to be something to the effect, the substantive effect, that the debtor's breach of contract renders a conditional debt unconditional. That has to be the thrust of it. And the Court of Appeal recognised that, because that's the opening proposition in the Court of Appeal's Mackay principle as stated at paragraph 85 of the judgment. And I did submit to your lordship yesterday that there is no English authority which states and applies any such principle to make a conditional debt unconditional on the debtor's breach, with the exception of a batcher. And the trilogy of cases which are put against me are Hotham, Panamina and Corey. We dealt with them in our case at 111 and following, page 46, the bundle in some detail. I'll just, if I may, make the bullet points as quickly as I can. In substance, they are all, in my submission, on all fours with Home and Guppy. They are all cases in which the money in question was the contractual payment in quid pro quo for a service to be provided by P. They are all cases in which P had completed provision of the service, carrying and delivering the cargo, repairing and redelivering the ship, transferring the waste. They had done the work. They are all cases in which the contract required P to obtain a certificate in order to be paid for the work that P had done. P was not contractually obliged to obtain the certificate. The certificate itself is not part of the work. It's not part of the service. The service was complete without the certificate. The contract terms required the certificate in order to get paid. Fourth, they are all cases in which D, the party who was to pay for the work, prevented P from obtaining the certificate. In Hotham, D broke an express obligation that his agents would certify on reasonable request. In Panamina, D stood by while his surveyor imposed uncontractual conditions in circumstances where it was D's obligation to either put his surveyor right or replace him with a more willing surveyor. In Corey, D just sat on his hands and did nothing when it was his obligation to provide a certificate within a reasonable time. They're all analytically, as I say, equivalent to Home and Guppy. P does the work. To be paid the full price in Home and Guppy, P needed to complete the work within a deadline. D prevented P from doing that. D then claimed that D did not have to pay the full price. The court said, no, you cannot rely upon your own prevention to withhold part of the price. And that is the medieval penal bond principle. That's not some novel principle about treating a conditional debt as unconditional. That's the old law. That's the law of roll. That's the law of commons. And the reason you can tell that is that those are the authorities cited in Hotham. The authority cited is Roll. In Panamina, the authority cited is Hotham itself and Robertson Bury. Robertson Bury is a prevention case. The authority cited in Robertson worry, it's Commons Digest. None of this is new. This is ancient law. It's orthodox law. Finally, there are two other orthodox analyses of these cases. First, the Dominique Karen Vatis, because the work can be done, it's natural to construe these as cases where the money's earned. Secondly, precisely because in each case D's act of prevention was a breach of contract, these are straightforward cases where there's a claim for damages equivalent to the money which would have been payable if the contract had been performed. That's not the case here. And my learned friend suggests, well, if there was prevention in these cases, then there was prevention in this case. But what that ignores is that what's being said in Hotham, in Panamina and Corey is that we don't have to pay you for the work you've done. These are all cases in which what D is seeking to do is to subtract value from P, as restitution lawyers would say. There's a transfer of value by subtraction because P has done the work. And D is saying, I'm not going to pay you for it. There's nothing like that here. We do not claim to forfeit anything. We don't say they owe us money. We don't say we don't have to pay them for work they've done. There is simply no analogy with respect in my submission between those cases and this. And it's his job to do it. Thank you. My Lords, there are so many other points on which it would have been my privilege to make oral submissions to your Lordships. But I'm afraid that we're given where we are. To the extent I've not dealt with matters orally, I must refer your Lordships to my written materials. Thank you very much.
Thank you very much, Mr. Eaton. Well, we're grateful to Council for the oral submissions we've received, and we also have very substantial written arguments. Obviously, we'll take all of that into account. We will evidently we won't be in a position to give you a judgment, I think, until the autumn. The court will